session of the day on the discursive turn in copyright conference at the University of California, Irvine. We will hear first from Professor Jessica Silby, Northeastern University, and then we'll have commentary on her paper by Professor James Nesbitt here from UCI. Professor Silby, the lectern is all yours.
Okay. All right. I'm going to try not to use this. Let me know if you can't hear me. So we've all made it to the end of the day. This has been really great. It's a pleasure being here at UC Irvine, and thank you to the UC Irvine community for hosting what to all of the law professors in this room is like a dream come true for many of us. So with collaborators, I have been studying digital photographers to understand their photography practice as it has evolved in the digital age, both aesthetically and in terms of earning a living. So we're working together on a different paper that's about their actual business practices, how they've adapted in the digital age, and that paper is very much still in the works. This paper for this symposium goes in a different direction, and it seeks to understand the photographer's accounts of what makes their work original, and also what their anti-copying protection preferences are. And it does that specifically by reading their stories, their accounts of what they do, how they do it, and why they do it, through three seminal cases in copyright law. So specifically, I'm thinking about the story structures. Do I need to be amplified? Okay. I'm thinking about how the cases and the photographers speak in certain story structures. That is, they moralize reality in the accounts they provide of photography. They embed in that moralizing a social situation. That is, they make certain assumptions about the context of the moral. And there are specific formal features of the story that operationalize the meaning of the moral and the social situation. And here I'm drawing on Carol Levine's work on forms, and specifically the form of the hierarchy as a way of understanding how the narrative is structured. So before digging into the stories in the cases and the photographers' interviews, so I'm happy to answer questions about how many people I've interviewed, how the interviews go, how they stratify. I love talking about that, but there's not enough time, and we could do it in Q&A if people are curious. Let me tell you where I end up. So the first earliest case, Burrow-Giles versus Sarony from 1884, is actually the case that most resonates with contemporary photographers in almost all ways. That is, its standard of originality, its distinction between authored or rendered works versus ordinary works, its distinction, I think, that it makes between professionals and amateurs, which the photographers also insist upon. And then, so that way the digital photographers of the 21st century are very old-fashioned. They resist the evolution of copyright law in Bleistein versus Donaldson, the 1903 case that insists on a market-based evaluation of aesthetics, and it flattens the originality standard. And they also resist Feist, the most recent and important case on copyright protection, insofar as Feist devalues hard work as a measure of value, which undermines the importance of craft and discipline. So for the photographers, the legal account is both too capacious, that is, there's too many authors, and too flat, protects too much, and often not for the right reasons. They also, the photographers also describe abusive business practices of publishers, platforms that take advantage of ubiquitous authorship thanks to copyright's contemporary promiscuity, all to the detriment of photographers on whose shoulders they believe the future of photographic art relies. So I'll admit straight away that one of the questions with which I struggle is whether I care about whether professional photography is going to survive in the current form. I really struggle with this as I get to know these photographers day in and day out. But I do care about reliable journalism. I really do care about that. And I worry about abusive business practices that prey on the asymmetry in negotiations, that enriches corporate wealth, and lopsided accumulation of capital worries me deeply. And if copyright is to blame for any of this, I think I will worry with them. But I'm not sure whether copyright is to blame for this. So I'm open to that option. I will note, however, that the social situations that are described in the legal cases versus the photography cases are different, or the photography accounts are different. That is, copyright law assumes certain things in the background of making photography and distributing photography that are entirely fictitious today. And I think we should care that, that the law is assuming certain things about the social context that we are not hearing on the ground from photographers. So that at least I think we should worry about. So let's get to the cases. Burrow-Giles versus Sereny. So this case, as many of us know in this room, considers the copyrightability of photography in itself. That is, because photography was this new technology and it produced this mechanical reproduction of reality, the question of whether photographs were authored at all was the question. And the famous photo was of Oscar Wilde by Napoleon Sereny. And this actually was just not a hard case. Sereny was a famous portrait artist at this time. The photograph was described as harmonious, forming the original mental conception of Wilde and Sereny's mind. If any portrait was authored, that is rendered and superintended and formed and costumed, it would be this one, and it would be by Sereny. So it wasn't hard at all that this was an original expression, that the ideas of Sereny were given visual expression, that he was an author, an originator of that image, and that copyright was granted for the exclusive right of man to the production of his own genius and intellect. But underlying, I think, what is an easy case on those facts is a tense conflict between humans and machines. So here's our first hierarchy. And the justification, really, for one controlling the other, and copyright protecting the former and not the latter. In it are rumblings of fear of automation, desire for control over it, and distinguishing the personal contribution from mechanical reproduction. In doing that, the court describes what copyright does. That is, it protects people, not mechanical processes, and why, and that's because human intellect has will, which is the source of its moral authority. That's what I think is going on in this case, involving the origination, the making, the producing, or as the inventive or mastermind. So this embeds another hierarchy in the narrative. That is, there are things that are going to be unprotected by copyright based on this understanding of the story, and that is that there are some things that are going to be original, and there are some things that are going to be ordinary. And this case makes it clear that, that the accuracy of the representation, which is the photograph's highest merit, to the ordinary production of the photograph, in that case, copyright is no protection. So in other words, when the machine is in control, there's no copyright. So not only do humans control automation, but the inventive mastermind stands over the manual operator. So let me tell you that the contemporary photographers, just as I've been interviewing them, they just repeat this as if they've read this case. They just seem to really understand that this is their practice. So here are examples of that. And so when I do these interviews and I share the data, I like reading the data to you, even though you can follow along, because there are intonations that I am remembering from doing these interviews that I would like to at least share with you. So this is a New York-based commercial photographer who is explaining the difference between who is the author or owns the photograph when there are assistants involved. She says there are instances where the assistant might press the button for the photographer, where the photographer has directed everything to that point, and they might make their assistant sign a work-for-hire agreement. I had asked about that. And I personally never had a problem with that concept, because I think taking pictures isn't just about pushing a button. It's about all the stuff that happens beforehand. If I was handicapped and I couldn't push the button and I directed the technician to push the button for me, it's still my photo. It's how I see that thing. So most photographers I interview had some version of this story. So here's another, Sarah Newman, and she situates the ubiquity of photographs within the pre-shutter activity, which is what was going on in Sereny. So she says, everyone has a camera. There's a shit ton of pictures, and the quantity of floating pictures, and everyone's a photographer now, and all that stuff. So there's that. And then in terms of originality, or making something new, photography is different than other media, because it requires something to be existing in the world to base the photograph on. But photography's relationship to those objects in the world is that they're just more closely tied tied to that than, for example, drawing. Also, people often mistake and see past the surface of the photograph. A lot of people see the subject, they don't see the photograph. If there's a picture of a tree, they see a tree, they just kind of see past the mediation on the world. So that's important, the mediation on the world. It's like the Magritte painting, Susine pas une pipe, we've already heard about Magritte today. It's kind of like that. What is this? It's a picture of a tree. It's a tree. No, she said, and she says it's a photograph. It's the same kind of thing, but it's even harder with photography. Photographers are incredibly defensive about their authorship. That's what you're supposed to be hearing here. And then she says, I think many people don't appreciate what photography is as an art form, because I actually think what the art photographers are doing is much more complicated than many people can see. So here's one of her photographs called Secrets. So I think that photographers attend to the nuance and rendering of photography. To them, making photographs focuses our attention and shifts our understandings. It's not merely mechanical in any way, but it's part of a larger conversation that they are shaping and having with and about their world. They understand art. Here's another one of her lovely pictures. They understand art as cropping the world, prioritizing a certain set of images and what is an infinite degree or an infinite number of perspectives. It's more what a photographer leaves out than what they include. This is Lee Crossan. This is one of his photographs, and if you can't see his feet in the boat, you should make sure you can see his feet in the boat. Okay. And then Allie Campbell adds, we don't have much visual literacy now, and this is the anxiety that they have about the relationship to audiences, understanding what photos mean or how they're taken or how to interact with them. So these accounts describe photographers adding to the understanding of the world through their aesthetic renderings. So photographers accept Burrough-Giles' distinction, I think, between rendered and ordinary photos. They assume that. And they think that ordinary photos do not cultivate the kind of critique of seeing and understanding that photographers aim to achieve through their practice. So if I'm going to put words in their mouth, which is what scholars often do when they're doing ethnographies like this, I think they say that ordinary photos don't promote progress, which leads us to Bleistein. Okay, so Bleistein was a dispute in 1903 between competing lithography companies over a circus advertisement. The question, as many people know, is whether the copyright law was going to extend to tawdry pictures or mere advertising, given the constitutional prerogative of progress. In deciding that it does, the court extends the originality standard from Burrough-Giles, stating that any human reaction upon nature will be original because any personal reaction upon nature always contains something unique. So when Holmes refutes the contention that ordinary posters are not good enough to be considered, because that's part of what was being argued about, he announces the famous anti-discrimination principle, which we've already heard about today, and Barton has written a lovely article about. And he announces this extending copyright to more than fine arts and flattening the distinction that Burrough-Giles made between ordinary works and rendered ones. This anti-hierarchical and populist sentiment in this passage, I think, is laudable in principle, and it's often commemorated as deeply democratic. It reflects, in many ways, Holmes's opinion dissent 2 years later in the Lochner case, where he criticizes the court majority for striking down New York State's fair labor laws on the basis of just a policy disagreement about whether and how bakers should be working in terms of their hours. He was trying to protect bakers against abusive labor practices, and the majority of the court believed in freedom of contract. Justice Holmes said that judges should defer to local policy like that. And I think in Bleistein, he apparently is doing a similar kind of thing, honoring the everyday creativity as promotive of progress. Judges should not second guess aesthetic value and should defer to the market in aesthetic work. So this is all declared against a very idealistic background, assuming certain social situations of fair labor practices, unobstructive creative play, and I think a functioning democracy. For Holmes, in the age of mechanical reproduction, when mass production threatens to erase individuation, democratic decision-making and populism characterize the hero, and elitist judges are untrustworthy antagonists. So the photographers in today's age of digital reproduction, I think they challenge these assumptions of the social situations. They tell a very different story. Creativity of the photograph, which they think law has no business assessing at all. Aesthetic borrowing and stylistic influencing through practices of resemblance and imitation, which they think the law has no business obstructing. And, this is a little bit of the kicker, verbatim copying and reuse, which they think copyright law is supposed to constrain. So the first principle of photographic creativity accords with Bleistein's personality concept of authorship. The last two remain quite contentious in copyright doctrine today, and that's what I want to share with you from their accounts. Photographers demand payment, as far as I can tell, for every verbatim use that permeates in business-to-business transactions. And this is because, as they've explained to me, payment for a verbatim use, an exact copy, respects the work, not only the photograph, but the work that has in the photograph, and sustains the practice of photography as a profession. Even if, under copyright law, it would be exempted as fair use or some other limitation. So they call these usage fees. So when I'm putting all these pictures in my PowerPoint, many of the photographers I spoke to would have expected me to pay them for this, $150, $200 for sharing it with the world. Here's a photographer in New York who explains that because they, me, other people, don't come from an industry where you get paid for that kind of work. Like that kind of work is just incidental to the profession, whereas in photography it's not. That is our unit of currency. Usage rights are the unit of currency in photography, not the audience. We want an audience, but the ticket to see the show is the usage fee. Now, however rigid photographers are with regard to exact copying like this and payment on a business-to-business transaction, they are very tolerant of other kinds of reuses for aesthetic or stylistic purposes. Uses that would be considered infringements, derivative works, for example, by most standards. They rarely balk at those kind of remakes because they think it promotes more photography. They think it promotes skill development, and they think it promotes a professional class. So here's examples of that. So Ashok Sinha says, I kind of felt a little flattered when these good artists, they were artists and they took one of the image of mine and they said they were inspired by this image. And they took some other image and I'm like, all right, you know, they're not selling it per se. Of course they were selling it, but he didn't think, not selling it in a business-to-business verbatim transaction, verbatim use. So this is one of Ashok's striking pictures. Lee says, I think it's a question of intent. What's the person trying to do? I would have no problem at all. They would flatter me and nothing else. And again, I actually support this. It needs to be there. That's the art. Like we're saying, this is a conversation that needed to happen, and I just think this is really the only way that it would have happened. So I understand these differing positions regarding compensated versus uncompensated uses as related to their insistence on the difference between professional and amateur photography practices. I'm still trying to conceptualize their thought process, but they think anyone can be an author. That is, authorship is open to everybody. Everyone needs the freedom to create. That is, copying the copy is fine under certain circumstances. And everyone should be able to sell their photos as photos in the way that they think photos should be placed. All of which to them develops a discipline, a professional class of photographers. So Bleistein's story of democratized copyright explaining how authorship is open to all, I think merges subject matter scope, that is what's the original work of authorship, with protection against unlawful copying. And I think photographers insist on a distinction between those two things. They insist on this distinction between professionally made photographs and ordinary ones in terms of an economic linchpin of sustainable photographic business and aesthetic practices. And they complain vociferously about abusive contracting practices driven by consolidated media companies and platforms, such as Getty and Time and Condé Nast, which are driving down the price of licenses and day rates despite a growing breadth of licensed uses. So they're fighting a different kind of fight than an anti-copying fight in general. So here's a photographer talking about the impact of digital photography on shrinking budgets, this devaluing of work. The digital realm, I think, has brought, I believe it's a good enough. There's so much more content out there. People are satisfied with less. And I think that directly impacts budget and why they'll pay less. And I've seen budgets just decrease and decrease. And you know, once they pay less, why would they pay more for something? So that's Carl Tremblay. Here is Rick Friedman, who says, people seem to have a lot less respect for the photograph because everyone runs around with their iPhone and does it. It's only a photograph, they say. I don't see what the big deal is. I've actually had people say that to me. I've also had people say to me when we've done a job, your pictures seem to come out better than our staff photographer. Actually, we shot a job at a hospital, and the head of the communications called me and said, your pictures, thanks, Dan, your pictures look a lot better than our staff photographers. Can you explain to him how you do it? So when Friedman, this is one of Friedman's photographs, when Friedman relayed this story with both sarcasm and incredulity, it's like, why would it be surprising to people that his photographs, his 20 years of experienced photography would come out better? And why does this person think that just explaining how to do it was going to do the trick? So they're insisting on distinctions between amateur and professional photographers, I think, as a measure of fair compensation, is a fight against certain forms of erasure of invisible labor, that is decreased budgets that are diminishing payment for their work and skill, and erasure of their identity as artists when they seek attribution, which copyright does not require, and they seek permission, which is required, but only sometimes. On this last point, I just want to say that on attribution and permission, they really resist a recontextualization of their work. So back to what we were just talking about with Demotica, here is Allie Campbell. She says, I think, you know, if someone were to lift my photos and use them in a Breitbart news article, like I'd be livid, right? Because I'd be like, I don't want to have any association with that. They are very upset about that kind of recontextualization. This is one of Allie's photos. So Bleistein has nothing to say about this kind of thing, except that its subsequent history as an anchor in the copyright canon has made self-actualization as a purpose of creativity and authorial attribution largely irrelevant. And if photographers had their way, I think the scope of anti-copying protection would narrow, and the purpose of protection would shift to promote aesthetic experimentation, professional development, and respect. And this leads to Feist, my last case. I'm not going to say very much about Feist because I think the point is fairly clear. Feist and the photographer's accounts conflict when it comes to labor equity. Hard work and skill is largely how photographers define the value of what they bring, and yet copyright doesn't protect it. They would agree that Rural's telephone book was full of facts and was ordinary, but it was the result of significant time and effort and expertise, and it was copied exactly. Moreover, Feist was a capitalized company, ruthlessly competing with Rural, and photographers fear those kind of industry practices. No doubt, I think the photographers would have considered what Feist did as theft. So photographers describe two related harms regarding this kind of devaluing of skill and expertise in adhesion contracts that are coming from all of this kind of conglomerate platforms. The contracts that are contracts of adhesion that have been lowering all their day rates and their budgets. The first one, as we've heard already, is this good enough problem. You know, I think perhaps steals better work from being done because, you know, you have the ability to look at the back of the camera and say, we got it. So there are two issues here. One is that they're not being paid as much as they used to. And two is that the quality of the work has gone down. They are seeing a lowering of the aesthetic, and they think that is really a problem. They describe the reduction in price and broader contract terms of use without more compensation, and a lowering quality image of good enough problem as a good enough problem. They related to this is that there are no more time-consuming investigations, research for long-form journalism, reliable and nuanced photography. All is rendered on the extreme and is not part of the norm. And they think it's rendering our image culture shallow, repetitious, rather than conscientious and diverse. And so one question we could ask is whether the social situation of shrinking wages, lopsided contracts, consolidated media, and unorganized freelancers is really a copyright problem rather than a labor problem and a organized labor problem. And I think that's a real question to ask. In the end, we have these very two different stories. On the one hand, law says copyright is essential to creative production and dissemination. On the other hand, photographers say that copyright will shape our professional identity in many ways, but fair labor standards are essential to promoting aesthetics and business. And I hear that in them. And then the question becomes, who benefits? That is, it really seems like who benefits from copyright law under the contemporary digital scheme? It's the publishers and the platforms based on the contracts. And that's really a very old story. That's not a new story. That's an old story. And so if we were going to ask them, and that's one of the I'm asking, is how in the digital age are we going to promote progress of digital photography or progress of science and useful arts, we go back to these other binaries, more and better, efficiency and affordability, free markets versus fair pay, all of which I think await analysis and redress in the 21st century. And whether copyright has a way to add to solving these problems, I am awaiting an answer for that.
Professor Nesbitt, we're going to try and lower the shade just a little bit here for your slides. While you bring your slides up, we'll play with this. Is it obvious how to do this?
Those photographers would hate the amount of light coming into this room.
That's right.
I'm not sure.
Okay.
Looking for shade?
Yeah.
Yeah.
Do you know which one it is? Thank God for you, Will. Oh, the one that says window shades?
Just share, right? The back. There you go.
There we go.
You're the best.
Thank you so much.
Oh, I'm sorry, excuse me.
You're a true art historian.
So thanks to Dan for the invitation, to Adelina and all the staff at the law school for putting this together. It's been a real pleasure on my part to participate. Am I sufficiently mic'd, or do I need to? Am I good? Okay, great. And of course to Jessica for her terrific paper. It's been a pleasure reading your work, and also a challenge to try and formulate a response, because I think your conclusions, the ethnographic approach is great, and the conclusions I find compelling. So I thought it might be a productive approach, in fact, to do a little thought experiment, which is to examine the inverse of your terms. That is, instead of addressing the general statements, and this is something that Jessica theorizes more specifically in the written text, about the general statements as a kind of storytelling from the court versus in light of particular statements from these individual photographers. So I'd like to propose that we instead, or in addition, look at a general take on photography placed in dialogue with particular statements from IP lawyers to see what further perspectives might arise. While admittedly the history and interpretation of photography doesn't have an equivalent authority to the Supreme Court, I'll instead allow the artists and perspectives that appear with a preponderance in published writings and university syllabi of photographic history to stand in as something of an accumulative rather than singular authority. Following Jessica's lead, I'll begin this general perspective on the history of art photography as distinct from everyday or ordinary photography of the past century or so, which covers more or less the same ground as that from Burroughs-Giles to the present. Duchamp, we've seen already, so I won't say much here, just to note that the one work on the right that I selected shows, well, both works show that the ready-made, in fact, is reproducible, and the work on the right shows an additional sense in which it's reproducible in its context of display through shadows. I'd like to highlight the ready-made and also the reemergence of the photogram in the early 20th century. We see, and I say reemergence because we see on the left one of the earliest photographs by photography's co-inventor, Talbot, who produced photographs without cameras by laying his subject directly on the paper and exposing it to light. I won't address this at all, but just to note that copyright is also an interesting issue with respect to Talbot's invention in England versus Daguerre's in France, because the one was patented and the other was not. In the early 20th century, the artist Man Ray, American who was working in France, returned to the photogram, and it became an important part of the historical avant-garde practice of photography to work without the camera. And so to reiterate, the importance of the ready-made lies in Duchamp's insistence that artistic practice is based on the intellectual rather than the manual work of the artist, and can be expressed according to issues of authorship, display, and nomenclature, rather than so-called sweat of the brow. The significance of the photogram lies in the fact that it's made without a camera, and shows that camera-based photography, therefore, is but one aspect of the larger field of the photographic arts, rather than its singular mode of creation and existence. Jogging forward a few years, I'd like to highlight the rise of de-skilling in contemporary art of the 1960s. And we see here a couple local examples, Ed Ruscha on the right, your left, and John Baldessari on the right. Ruscha is making photographs out the window of his car between Oklahoma and California with the express intent of displaying his works in a book. This book is not the reproduction of the original photographs that exist elsewhere, but it is the work to be experienced, and is very purposefully not employing the kind of traditional techniques of photographic composition. Baldessari takes this sort of distaste for traditional composition a step further by purposefully staging a quote-unquote bad photograph, and that the palm tree is coming directly out of his head, and then pays a professional sign painter to write the word wrong on the bottom. And so none of this is actually rendered by his hand per se in the creation of a painting. So the key move here folds the basic insights of the ready-made directly into photography, insisting that meaning, significance, and achievement arrive from how images operate from within a completed work of art, regardless of the skill involved by the artist or anyone else in its production. This idea would find more radical expression in the work of the pictures generation, to arise in the 1970s, who repurpose or appropriate image compositions created by others, the most radical example perhaps being Sherry Levine, who's been raised earlier today. We see here in Levine's Untitled After Walker Evans, beside a photograph by Walker Evans of Allie Mae Burroughs, that what Levine is doing is not copying the original subject per se. Her subject is Walker Evans' photograph, as opposed to Allie Mae Burroughs as the photographic subject. So here, Levine realizes one of the fundamental implications of the ready-made for the reproducibility of photography, namely that photographs and photographic images can be found and adapted by someone else, akin to the manner that any industrially produced object can be found in the world. As a final note, and this slide admittedly is a mash, but I wanted to quickly run through a kind of turn that happens with the appearance of digital photography in the 1990s in particular. So beginning on the top left, the initial response to digital photography tended to be around its reliability. So this famously digitally doctored cover of Time magazine from O.J. Simpson's mugshot. There was a concern that because digital images could be manipulated, that they couldn't be trusted. A scholar named Andre Guntert has shown this to be not the case in any way with the release of the Abu Ghraib photographs, one of which we see on the bottom left, which were taken digitally and distributed through the kind of networks that would potentially allow this kind of manipulation. But when they were released, no one questioned their authenticity because of their digital production. Which is to say that the more impactful influence of digitality in photography has turned out to be through the platforms of social media rather than that have arisen in the 21st century, as opposed to the production of the image itself. So here's a work of contemporary art by an artist named Penelope Umbrico, who takes ordinary photographs from Flickr and turns them into fine works of art when displayed by the thousand on the gallery wall. So she hasn't taken any of these photographs, and these photographs were not taken for the purpose initially of being photographic works of art per se. We're stuck here. The arrow key is broken.
Neither the keyboard nor the...
Did it freeze? I don't know. I guess it did freeze. Sorry about that.
is it this
It's
one
the
here?
top one.
Oh,
This
the
one
top one.
might be.
Okay, gotcha.
And I tried not to make the file too big for this purpose.
Okay. Let's go to,
I can just take it from there.
sounds good.
Okay, so part B. In response to this history of conceptualism in photography, I'd like to return to Richard Prince. This was brought up this morning in a new case brought by the photographer Donald Graham regarding the alleged copyright infringement of Graham's photograph, Rastafarian Smoking a Joint, which we see here on the left, by contemporary artist Prince for an untitled inkjet print on canvas in Prince's series New Portraits that he exhibited at Gagosian Gallery in New York City in 2014. And as of July of this year, the case is moving forward. Prince, it should be noted, was an original member of the Pictures generation. I'm just skipping, so I'll not talk about Carriou and that we've discussed this already, but here's an example of a very similar subject matter of photographs and collage from that particular case. Commenting on the new case of Graham v. Prince are two practicing attorneys. I wasn't able to do the ethnographic work myself, so I'm quoting from ArtNet News. Here's Paul Goldstein, a professor of intellectual property law at Stanford. Quote, "It's a basic rule of copyright law that infringement is measured not by how much the alleged infringer added, but by the amount of the copyrighted work that he took. So Prince's modest additions don't, as a fundamental matter, excuse what he did. Even in the Second Circuit, where this case is being brought and which has the most liberal standard of fair use and the most liberal open sense of transformative use, I don't think this one makes it as fair use. One tentpole decision to consider is Carriou v. Prince, which involved more substantial changes to the image. Here there is no change in the image, though there is modest change in the framing. If he's commenting on social media, let him take things other than copyrighted images. The attraction of Graham's image for Prince is not that it's taken from Instagram, but rather it's a truly arresting image. Looking at the images he used, they're all pretty compelling images. The credit for that goes to the original author. There's no justification for getting on the back of a copyrighted work to make your comment, and I'm not sure what the comment is. If you can get away with this, what is left of copyright? Question mark, end quote." The next comment is from attorney Claudia Ray, a partner and IP specialist at the New York office of the firm Kirkland & Ellis. She adds, quote, "Mr. Graham's lawsuit against Richard Prince for infringing the copyright in his photographic portrait of the Rastafarian offers the intriguing possibility of a do-over of Patrick Carriou's similar claims that Mr. Prince infringed the copyrights of Mr. Carriou's photographs of Rastafarians. Here, the complaints exhibits suggest that there were few, if any, changes to the underlying image itself. If that turns out to have been the case, it will be interesting to see what the court does with what the complaint presents as very literal copying. Another question is what, if any, impact Mr. Graham's track record as a fine artist and commercial photographer will have on the legal issues. Graham being a much more established photographer than Carriou, of the exact kind that the commercial photographers would identify with, I believe. So to finish the quote, ultimately the case has the potential to answer the question of whether any photographer can succeed on a claim involving so-called appropriation art, and thus it is sure to be closely watched, end quote. From these comments, Ray appears to be less convinced and instead more intrigued about the potential differences between Carriou v. Prince and Graham v. Prince, while Goldstein is more conclusive in suggesting that Prince has indeed infringed upon copyright in the comparison of works we see here. Taken together, Ray's and Goldstein's comments point to a need to come to terms with the conceptual turn in photography to arise in the past century, alongside the appearance of new productive image-making and editing technologies to appear more recently. I'll close by suggesting 2 points of conclusion to the dialogue between these images and the general history of photography I've outlined. The first pertains to obsolescence and technological innovation. By outlining a different trajectory of photographic aesthetics than the one invoked by the commercial photographers interviewed by Jessica, I hope to show that the criteria of judgment regarding photographic quality that these commercial photographers repeatedly invoke is not the only set of criteria for evaluating the artistic quality of photography. At the moment of any new technology, its initial use tends to occur within a pre-existing framework. In our lifetime, for instance, we might think of the digitization of music on CDs, a shiny plastic version of vinyl records, before the arrival of the iPod. In the history of photography, 19th century practitioners like Napoleon Sereny, Henry Peach Robinson, and Oscar Rylander likewise initially used cameras to compose portraits that borrowed from the paradigm of the painter's studio, oil paint on canvas or panel being the recording technology of naturalistic depiction that predominated immediately prior to that of photography. Regarding contemporary commercial photographers concerned about the loss of income needed to maintain their studios and preferred way of making photographs, one might wonder whether the disappearance of their studios has been looming far before the advent of digital photography, where the protection of pre-shutter labor activities under copyright law shielded an already obsolete institutional practice. To draw a comparison, we might think of this as akin to protecting the labor of plaster preparers in the 15th and 16th centuries to maintain the business of fresco painting against the emergence of oil painters with their simpler processes of making images and the potential for faster reproduction and greater circulation, what Benjamin called exhibition value. Not unlike the non-professional digital images disparaged by today's commercial photographers. And to be clear, this is not to reject their criteria of judgment, but rather to contextualize it historically and institutionally. A second and related point involves the category of contemporary photographers itself. As evidenced by the historical and also market importance of photographic works that either don't involve a camera, such as those by Man Ray, or those that reject traditional photographic aesthetics, as in those by Rouchet and Levine, we might recognize that there are many kinds of art photography, for which that made using cameras and traditional techniques of lighting, composition, and darkroom printing, etc., constitute but one category of the field as a whole. Richard Prince, for instance, began his career using a camera to shoot photographs from magazines and stock prints, but now produces photographic images using screen grabs and image editing software. The German artist Thomas Ruf essentially uses the same procedure to make his series of JPEG photographs. Pairing one of these beside Prince's new portraits, the degree to which Ruf changes the appearance of his found images by plumping up, as he likes to call it, their pixels, would seem to satisfy the particular complaints of Goldstein about transformative use, but we might consider the idea of digital art that Ruf's works invoke, which is mainly that of the 1990s, of treating the digitality of digital images as defined primarily by the code used to generate them. By way of contrast, regardless of what we might think of the political implications of Prince's new portraits regarding race, gender, and nationality, or even what we might think about Prince's own penchant for provocation, the new portraits do in fact engage the more impactful turn in the technological invention of digital photography toward the spread of images through social media. Prince's minor additions of text and changes in cropping to these works are not nearly as original in terms of conceptual originality as the collision of that the new portrait stage between the explosive fluidity of images that circulate online and the fixity of printed photographs tacked to a gallery wall in the tradition of the static visual arts. In other words, their significance arises precisely from their internal juxtaposition to the work of an accomplished commercial photographer. I also think that there's issues to address about the case of images used for journalism, as Jessica raised, about the issue of markets, the specific markets that these photographs circulate within, and also about different ways that we might define and understand aesthetics. But I think these might be best for the Q&A, so I thank you.
Jessica, thoughts, responses?
Yeah, I just have just quick tidbits from the interviews. So the Abu Ghraib picture and the O.J. Simpson picture. So I was not, so you do this ethnography and then you don't know what you're going to hear. And one of the stories that really surprised me that I hear over and over is when the shift from film to digital occurred for many of these professional photographers, it happened around 9/11. And it was generated by demand from the news outlets that they wanted the images quickly and immediately. And so many photojournalists and then commercial photographers started just within 2 years, everyone started using digital photography, and it was driven largely by the news. And what's interesting about it, no one questioned the authenticity of those photos. He's absolutely right, that the anxiety about digitalization is not about authenticity at all. And then the way they recapture the value of their labor through the quick pace turnaround of the digital photo is so many of the photographers describe not as much pre-shutter activity anymore, but post-shutter activity. They talk about how much time they spend curating all the photos that they've taken in the shorter period of time, all the new equipment that they've had to invest in to fix the photos and to frame them and to fix the pixelization and stuff. So they take old stories about labor and pre-shutter activity and tack them onto the back half of it, in order to recapture, I think, the stories of value. I guess the other thing I'd say that you said that I think is really true is that it's not as much for them about the production of the image. What's new about the digital age for them is not the production of the image, but it is the platforms on which their images circulate. And they spend a lot of time worrying and managing what they want to be different licensed uses. So on Instagram, on Facebook, on the front page of the web versus the third page click through, and they expect that all those different uses will have different contract terms. But in the digital age, the platforms have consolidated all of those, and that's what I was talking about, the contract of adhesion, so that the diversity of platforms, which is good for many of us as audiences, has been rendered for them a substantial diminution of revenue. They're seeing more demand and less revenue for the same thing. And so you're absolutely right. They load up on the labor of the work, but they see the diversification of dissemination on the platforms in the digital age. So it's not about production, but it's about dissemination.
Okay. See hands coming up already for questions. Anne Marie Brady.
So I guess if you really want to make photographers' heads explode, you can just tell them that we're all pivoting to video, which is a thing, actually. Yeah. I'm just wondering if you asked them in your interviews at all about takedown practices under the DMCA, because there's the large study that Joe Karaganis and oh my gosh, I'm blanking on her name. Jennifer Urban. And that has interesting stuff about image search.
Yeah.
And photographers' takedown practices with respect to Google image search. And then also, I just wanted to mention the pending bill for copyright small claims, which is largely being driven by photographers and sort of statutory damages and all of that. So that's just another, the enforcement side of this is also kind of interesting, and the antagonism that they feel for the platforms.
I have so much to say about that, and I'll try to keep it short. But first of all, I asked them all about takedown practices, and generally they do not send cease and desist letters. It's too time consuming. And when I asked them about reverse image searching, like you could have a search firm do this for you, and they could do it. They're like, why would I even want to know? That's what they say. Why would I even want to know how much my images are being infringed? They hate the DMCA because they think it's a freedom to infringe. It's until I ask, it's up there, so they hate it, but they don't, most of them do not bother. But many of them talk about several famous photographers, one of whom is in LA, who I've been chasing for months, who makes a lot of money on takedowns. So there is a small, a slice of business that can be made through that, but most of them don't bother. And that just goes to the point that anti-copying protection is not really what they're worried about most of the time. They're worried about being paid for placement, and the enforcement is just a waste of their time. The small claims, for the same reason, but if in Britain, there's been a study in Britain with the small claims court, and 60% of the plaintiffs in that small claims court are photographers. So my anxiety, from the perspective of what could happen in the United States if we do this, is that it's going to wreak havoc on what I think are harmless circulation of verbatim photos. I'm just going to be honest about that. My last thing I'll say about the lobbying efforts of the photographers, and this is sort of triggering a conversation that we had at lunch with Brooke. So at the Orphan Works Roundtable in 2014, the National Press Photography Association was represented there, and on the table was the policy of just making orphan works available, for no payment and putting in sort of like a trust fund for using it. If somebody comes out of the woodwork, we'll pay. The NPPA lobbyist lawyer stood up and attributed that kind of use for non-payment, even though the author is not available, as akin to the Plessy versus Ferguson decision. That is, it was such a harm that if we would give away this property for free, we would be making such a bad decision like this kind of, and he actually said that. And I just think that goes to the depth of how much these photographers feel, or their lobbyists feel, about their being abused in the contemporary digital age.
Betsy Rosenblatt.
Thanks. This is, I found myself as I was listening actually to each of you, but particularly to you, Jessica, about just thinking about how slippery all of this is and how sort of internally inconsistent it feels. But there's one thread that I wonder if you might comment on, because I think it ties in possibly with Anne-Marie's work, which is that it seems as if many of your interviewees, if not all of your interviewees, were not at all concerned with the preservation of meaning, whatever meaning is, but quite concerned with preservation of association, right? They don't want to be associated with Breitbart. And this is not something that we think of as a copyright issue, but it seems like it may be true to some extent of both of the artists that we've just been talking about. And I was wondering if I'm imagining that, or if that's something that you actually found.
So you're right that they are worried about association. They think they're making something that is valuable, that if put to bad use would be a tragedy. They seem not to be as worried about the meaning of whatever their photo is being changed over time. They're not worried about that. Actually, I think they anticipate that. But when they narrow the scope of their interest to verbatim uses in a business-to-business way, they are imagining a stability of meaning, which is why they don't want it being placed. And there's an insistence that the relationship with the subject be preserved. There's a deeply personal relationship to the subject matter, and especially when they're taking pictures of people or news, and they worry about that being put to bad use. I mean, there are a lot of bad actors in the stories that they tell, but not any derivative use. I have to say they're very tolerant of derivative uses. It's really just the verbatim uses in contexts that would create bad associations. You're right, I think. It's interesting.
Jessica, is there a connection between their feelings about, sort of verbatim or slavish copying and the view that you identified about the machine and the reproduction of facts, or the reproduction of what's in the world?
Yeah.
Those strike me as connected in an interesting way,
So it's
potentially.
There's so many inconsistencies, and it's sort of hard as a person who's trying to make sense of the interviews. I feel like maybe I shouldn't make sense of them because but there's a lot of nonsense. Let's just say, this is an example of an inconsistency. They regularly get contracts for right of publicity issues. Like they are regularly protecting. They take pictures of facts in the world and of people in the world, and they worry about reusing that. They do worry about the facts and about the news, but they don't somehow care about the derivatives. So there's an integrity to the image that they are worried about preserving. I think that's what it is.
Last question to Zar Saeed.
I wondered if there was a trade organization, a central trade organization or not.
Yes, ASMP.
And is it active?
Yes, very.
And independent? Is that who it represents, or?
They are independent, and many of the people I interviewed had at one point been officers in it.
Okay. So I find that very interesting because I haven't seen as much work as maybe I now believe there ought to be on the role that plays in organizing sort of inter-firm or inter-party governance in an area, and I'm seeing that in craft beer, which is why
right.
it's been so striking, and I didn't expect that having a common enemy would do so much to unify the other players, right? But I also live in a city that Getty, is very active in, and I wondered about that dynamic a little bit. And then I guess the last quick just comment is about the extent to which copyright internalist views can kind of blind us from thinking about other aspects like unfair competition, right? And like maybe it's just not about copying and we need to listen to, as I'm sure you're doing, but for other sources of law and indeed outside of law, like how is this just a business question and the business model's collapsing and maybe legal solutions don't exist for all the sorts of things that need to happen, but it might be a governance solution, there might be a business solution, or there may just be, I don't know.
So
It's a bit of a depressing
I
note.
just want to say that so many of the photographers that I've interviewed make a really good living. Like, they complain a lot about lowering wages, but they all have studio assistants, they have big studio, I mean, there's a lot, they make a lot of money. So the idea that the business is collapsing, I think there are fewer staff photographers. Empirically, there are fewer staff photographers, and I think they have to, their business they work harder for the same amount of money. And then again, at the beginning, I said, like, I'm not sure, do I care? I'm not sure I care. So maybe journalism. Journalism, I think there is a different story to be told with journalism. About the ASMP, though, so there's a common story that also comes out of the interviews, which is a generational story. So there are all these folks who sort of came of age in the 80s and 90s as commercial photographers, making a lot of money on the beat, and they all banded together in not a union way, but like a union, to refuse to sign some of the contracts that Condé Nast and Time were going to require of them. But then the younger group, this is the newer generation, come in, and they want to work, and they're going to sign these contracts. And once some of those contracts are signed that claim all rights for all uses in perpetuity, Time just stops going for the older photographers, and they'll go for the newer ones, and that's the way you get the contract accretion. And those folks are not part of ASMP. That is, they claim that the younger generation of photographers see less value in the quote-unquote union. And there is a direct comparison between SAG, the Screen Actors Guild, and how effective that has been in managing writers and actors in Hollywood, and the lack of that in the photography as freelancers, I think.
Please join me in thanking another great panel. And our thanks also, again, to Adelina Tomova and to the staff here, to our communications staff and our IT staff who made this possible. And thanks to you all for joining us.